Oh, hello, everybody. Excited to have you in class today. Today, we're going to go over the AP Gov assigned cases. So advanced placement classes that most students take in high school. There are 15 different cases on the test, typically every year. So we're going to look at those 15 cases today, but this is an introductory course. So what we want to do is we want to make sure you understand why did they put these cases together, a little bit about the cases, and the big ideas that these cases, when grouped together, talk about and get us to see over time in American history. So my name is Kerry Sautner. I'm the Chief Learning Officer at the National Constitution Center. I'll help guide us through this conversation today, but lucky I'm not by myself. I'm with Nick Mosvick, who is one of our senior fellows at the Constitution Center for Constitutional Studies. Let me get it all out. So
too many constitutions.
I was like, whoa. Okay, so let's get started. So Nicholas, when we think about like this first grouping of cases, and students, if you are going to be doing an AP court case, please feel free, AP exam, feel free to ask questions, but no pressure here. If we don't have to take the exam, we can still learn a lot from the coursework. When we look at this first kind of grouping, Nicholas, the big idea is to look at federalism. So the United States Constitution establishes a system of checks and balances among the branches of government and allocates or shares power between the federal government and the state government. One of your favorite topics, Nicholas. So it's great that we start off with this.
Yes.
So here's the thing. First of all, you need to define federalism for us to make sure we understand what they're talking about in this separation of powers. And then two, it seems pretty easy, but it's been tested over time. And these two court cases are really supposed to show the way federalism was spelled out in different time periods. So with that kind of big picture, what do we need to know about federalism? And tell us a little bit about these court cases.
Yeah, I think what you said gets us started in a good place, which is to say, we are talking about the distribution of power between the state and the national government, right? So we say federal, we mean the United States government, and federalism is part of that structural constitution that we talk about. So when Kerry says separation of powers, she's also talking about the structural constitution, but their separation of powers is the three branches of government at the national level and the ways in which they both share and have different powers and how that system works together. But we're talking about the distribution of power, right? And that's the point, right? So separation of powers is part of that. Checks and balances is part of that. Federalism is part of that. That's all in the structure of the Constitution. And it starts with the premise that states existed before the national government. They already had these existing powers, and the people gave only some of those powers to the national government, and then others remained with the states. We talked about that last week with the 10th Amendment, right? That's that theme of popular sovereignty and federalism that's so important to understanding the founding. So that's the big picture. And then the two cases, I think what they tell you broadly is that federalism has been pretty important throughout the history of the United States to understanding the Constitution and the major cases. So that first case, McCulloch, is really, I think, one of the first most significant cases of the Supreme Court and remains so today. This is the Marshall Court era, so we're talking about Chief Justice John Marshall. And as we suggested before we got started, this is kind of a taxing problem. But we mean that in the sense that this has to do with the national bank. So Alexander Hamilton, rather famously at this point, put together a financial plan as the first Treasury Secretary. And included in that was establishing a Bank of the United States, which was a controversial idea in 1790 and 1791. There was a big debate about it between Hamilton and Madison, but ultimately Hamilton won. A deal was made. Part of that was the location of the capital, but also Hamilton's financial plan. That first bank was chartered for 18 years. It was rechartered, it was rechartered by Madison himself, actually, as president. He signed the bill for that, even though he previously didn't think it was constitutional, but he said things have changed. We now have this precedent established. It was a 16-year term. They established it again for another term in 1817, and Maryland responded. So there was this outcry And Maryland responded by trying to tax a national bank because they said, well, look, I mean, Madison was right before. This is unconstitutional. There's no power given to the national government under the Constitution to create a national bank. Yes, there are financial powers over coinage and money, but there isn't a power to create a bank. That's something states do. States charter banks. The national government doesn't. So Maryland tried to tax the bank in order to prevent its ability to have an effect within the state. And this went to the Supreme Court, and essentially what Marshall said was, look at the supremacy clause. So first off, we know the national government is supreme when it acts. The national government has these powers. Congress does under Article 1. And over commerce, over money, over a variety of things. And Marshall's point was, look, it's not just the enumerated powers, just the text itself. Congress has to have choice of means by which they deploy those powers. And if they choose to act upon those powers by doing something like creating a national bank, that is constitutional. So that's basically McCulloch. I know, Kerry, you're giving me this. It's foundational, though. This is important.
It is hugely foundational. Yeah,
I think
really, it's more important.
It's more important than Lopez in the sense that you can't understand Lopez without McCulloch. It's not as if they stopped citing McCulloch, right?
Yeah,
they're still citing McCulloch.
How are they connected?
Right?
How are United States versus Lopez connected? Like, why do they put these two cases together? And then tell us a little bit about Lopez before we jump into the next grouping. Because in the next grouping, we have 5 cases that are connected.
I mean, I think the theme over time that people are arguing about, and we're now 200 years past McCulloch, is just how far does McCulloch go? Was Marshall talking about still government of limited enumerated powers, but those powers were pretty broad? Or was he going beyond that? Was it almost unlimited power? So it was really a question of how limited this was, right? And that's a theme of the 20th century, because you see in the New Deal court, you see in the 1930s, 1940s, the Supreme Court moved to a very expansive view of the Commerce Clause power in particular, in connection with the necessary and proper clause, which McCulloch also cites to say that's another reason why Congress can go and choose its means and sort of have a more expansive view of their power. Lopez is the kind of the pushback. We call it the new federalism of the 1990s, and it's the sense that the Rehnquist court, this is now Chief Justice William Rehnquist, and the 4 other conservatives on the court, were looking to limit just how far that expansive notion of the Commerce Clause could go. Here it was to say, can the federal government ban handguns within a school zone? And the response here, I think, simply put by the Supreme Court was, that's more something states do, because here the relation to commerce is so attenuated, right? You have to go so many links just to get to a national interest in terms of what is commerce and what can Congress regulate, that this goes beyond that limitation, right? In other words, there's got to be some sort of upward limit. And essentially the court said, look, there was another way Congress could have done this. They could at least have put a link to interstate commerce here that would have allowed us to uphold it. So it's just saying there has to be some threshold, and that's what this is really about.
So it's not like 30 degrees of separation doesn't cut it for the court.
Right, exactly. So okay. Now we're talking, we're moving to Bill of Rights.
Next big idea. Okay, so the enduring understanding, this is what the AP students will see when they get to kind of that high school level, is a balance between government power and individual rights. So I think it's really nicely wrapped up in Jefferson's words in the Declaration. We hold these truths to be self-evident, that all men are created equal, that they are endowed by their creator with certain unalienable rights, among them life, liberty, and the pursuit of happiness. That to secure these rights, governments are instituted among men, ... We can keep going on. So when we think about that balance between government and individual rights, this is what this group of cases are really looking at. Have we struck the balance? And what does the court say about the balance in each of these cases? And so I'll let you dive into this, because I think these cases really speak for themselves in showing the way the court interpreted that balance between the government and the individual. And they're not at odds. I want to make sure our kids know that. But there really is sometimes a push and pull between the two.
Or they're not inherently at odds, but they certainly can be, right? And that's the rub, that's the tension. I think in some ways, these can be grouped together, but they can also be separated, which is, I think, what you're kind of suggesting, right? Is because if we take Engel versus Vitale and Wisconsin versus Yoder, those look more like religious liberty cases. So yes, there the government has a particular policy, so that is part of it, right? In Engel, it is, what if a state sanctions school prayer in a public school? In Yoder, it's, can the public school system continue to compel students to go to school past the age of 13 if they're part of a religious minority these were Amish students, and that essentially by the age of 13 their families wanted them to come home and work. They didn't want them to be compelled to go to school anymore, right? Because if the government can compel you, it can also punish you if you don't go to school, including the parents, for saying that, no, we don't believe our children need to continue to go to school. So there, the Supreme Court said, yes, the parents actually do have a right there for a sort of exemption based on religious liberty. And we go back to freedom of conscience there. In Engel versus Vitale, that the court there said no, 6-1, I believe, that New York could not sanction government prayer, is what they would have called it, but it's in the school context, right? It's can you have a brief prayer over the loudspeaker, I think, in the morning in public school? The court said no. The next year they said the same thing for a Bible reading in a public school. In the 1980s, we see the same thing for a silent school prayer. That won't count either. We have a series of decisions after that have to do with like a high school graduation, like a non-denominational prayer, or one before a high school football game. All of those were no's, right? Because it wasn't the school context itself matters. We frequently talk about this, and we'll say the same thing with Tinker, but the school context itself is always important because it changes the answer to the question, what is the purpose of the government program? What is the government trying to do here, right? And so the Supreme Courts always keep that in mind. Okay, what is the point of public schooling? And so how does that interact with this set of rights? Here we're talking about religious liberty. And that's why it's different, for instance, when it's a government-sponsored prayer, like, for instance, one before a congressional session or a town government meeting. That's different than one in school. And it has to do with both the history of having those things, but also the context, right? School is different from a town meeting. And so that's important.
So many of these cases, it's about looking at what the family wants and what the school wants. And like you said, place matters, which I think is so clearly spelled out. Place matters with Tinker, but also what you say matters too. And that's with all the cases. This is about religion, religious rights, and then speech, political speech. So do you want to dive into Tinker and give us a little bit about Tinker too?
It's political and it's symbolic speech, right? Because we're showing that picture there. They're literally wearing these peace armbands in school to protest the Vietnam War. And these were smart students. I think they were brother and sister who knew that they were doing something symbolic too, right? They didn't have to literally say anything. Just the fact of wearing it, they knew said something. And the school's argument there is that this disrupts education, right? Again, that the context of public school is the school's mission is to maintain order. That Curry used that word, but let's keep it in mind here, right? As we're keeping order. And hey, if you're coming in here protesting the war, you're disrupting the classroom. And the Supreme Court said, no, this symbolic speech is protected. It's true that the school context is different, but also rather famously, the court said that behind the schoolhouse doors, you don't lose your freedoms either, right? Or your liberties, right? The Bill of Rights still applies. It's just a different context. So that left the door open to future cases in which the court said, yes, other speech actually does cause a problem for discipline and order, and therefore can be limited. But in Tinker, that was different because it was that, the symbolic speech, that's not disrupting things, right? That's
and
that was different.
Yeah, and students will walk away with it's political speech, so it's more protected, but it can't be like disruptive to a point that the mission of schools doesn't happen. Exactly back to what you said earlier. Now,
so you can see that they won, but it also sets up this standard and test going forward, which means you aren't going to keep winning. Essentially, right.
Now, the next one is, again, about political speech, but outside of the school. So it's so important. And I love that you said that where matters. So in a school is different than outside of a school in a newspaper. And we look at this case and how it bolsters the freedom of the press and looks at presumption of prior restraint. So explain to us kind of like the students, like, what's the big fear of prior restraint? And then I love this case because it goes back to like our roots as Americans and what we started with fighting for in the beginning. Yeah,
prior restraint is just a fancier way of saying that the government would stop the publication of, anything. Usually we mean a newspaper reporting or something like that before it happens. So to restrain, prior restraint would mean before publication. And that is Curry suggests, that's an old thing, right? That goes back to Jeff Rosen, our president's, one of his favorite stories, which is John Milton, the famous English author, amongst other things, Paradise Lost, also wrote something called the Era Apocrypha in 1644, which was complaining about the English government's suppression of the press through prior restraint. Licensing is what he was talking about then, but the point is it was restraint before publication. And so there's this long lineage in history of, we don't do that. That's one of the cores of this old idea of whatever freedom of the press is, that's a problem, right? Here, this is about the Vietnam War. So essentially, Robert McNamara, the Secretary of Defense, had secretly established this group to put together a report about 22 years in Vietnam, and included all these government secrets that they didn't want to get out publicly, including things like their involvement in the assassination of South Vietnam's leader, Gideon, in 1963. And so there is a gentleman, Daniel Ellsberg, who worked at the Rand Corporation and knew about this report, and he photographed all, I think, 4,100 pages of it, and then sent it in 1971 to a New York Times reporter. And that reporter began publishing it in June. And the Nixon administration sought to stop that publication by going to a district court judge. But as soon as they got that stopped, the Washington Post got it. And then 15 other papers got it. The Senate got it. And pretty soon they were before the Supreme Court because they were trying to stop the Washington Post next. And the Supreme Court said, well, no, you can't restrain this publication because what the administration argued was that this will get us to Schenck. They actually based this on the Espionage Act of 1917, that War I Act, and said, well, this goes against the government, right? Because it goes against their interests in defense and protection of good order. Yeah, we're talking about that thing again, right? Is it leaking government secrets and publishing them in the paper? That will be, it was the language of a prior Supreme Court case. It would be a grave and irreplaceable harm to national interest. Supreme Court said, no, the standard is really high for prior restraint. This doesn't meet it. Justice Black has our favorite quotes from here, but basically what Black said is, there's no way the founders would have ever agreed to this. This is the opposite of the freedom of the press in the First Amendment, because here it's saying, well, if the government has good reason, it can stop the presses. And we would never believe that to be true. So, right, it's all about how you view the question too, right? We talk about facts and circumstances and context, and it's also, how do you formulate the question at the heart of the case? And if you're Justice Black, you say it's not what the government has the wrong formation. It's the opposite, right? It's, you need a good reason in order to ever stop the press from sharing things, even government secrets.
And I love that kind of flipping around of the First Amendment in that statement, like flip it around. It's like, no, you have to come with the evidence and the good reason. You have to be above a unbelievably high threshold.
Yes.
But there are thresholds. It is not, the First Amendment is not unlimited. And that's why they put Schenck in here.
Yes, yes.
You may not
and that's why I made
with,
mention of it. Yep.
Thank you. You may not agree with Schenck. I don't love Schenck, but it really does set up this idea that the First Amendment isn't unlimited. There are times and moments where the government has said, okay, you've hit that threshold. So kind of put us through Schenck, and then we're going to jump to the next grouping. Four more groupings to go.
Yeah, well, that's the New York Times case too, right? Is that it's a strong case for freedom of press, but it doesn't overrule the Espionage Act, which is still on the books and it still gets used. And Schenck had to do with this other act that was passed. This had to do with the Espionage Act. The Wilson administration passed two things: the Espionage Act in 1917, and then the Sedition Act in 1918. They brought back the Alien and Sedition Acts in 1918 during World War I to suppress speech of opponents of the government who were opposing the war, communists and socialists who opposed military operations in Europe and the draft. And that's what Schenck was really about, is these groups of political minorities who are saying, oppose the draft, don't join the military. And here's a pamphlet we're going to spread around to tell you how to do so and why to do so. And so that's where this case came out of. And the Supreme Court upheld that prosecution. And it was Justice Oliver Wendell Holmes who wrote the decision here. We often talk about how he kind of reversed himself later and how that standard changed, which really Schenck got overruled in 1969 by the case of Brandenburg versus Ohio. But in Schenck, it was the clear and present danger test, which is to say, as you said, these free speech rights aren't absolute if, and at least in this decision, the government could show a clear and present danger. As I suggested, the court has moved away from that standard, though.
Yeah, they've gotten like a more clarifying standard now.
Yes, we use now imminence is what we call it.
Yeah.
So without getting into that doctrine, it's to say it's harder for the government to prove that they can suppress your speech. Exactly.
Exactly.
It raises the bar. That's what we're talking about. Yep.
So these three look at incorporation of the Bill of Rights. So incorporating is making sure that parts of the Bill of Rights stick to the individual, no matter where they live in the country, no matter what state they are on. So Gideon versus Wainwright, Roe v. Wade, and McDonald v. Chicago. Now, Gideon's one of my favorite stories, but we'll go through all three and just kind of look at each of the pieces of the Bill of Rights that they incorporate. So real quick, give me a 1 minute synopsis on incorporation, and then we'll fly through these three because we have a lot more to do in 8 minutes left.
Yes. Yeah, no, so we should just treat this as incorporation and say that these are just a handful of examples. If we want to do incorporation, we could do 10, 20 cases. There's a lot here, and that's because the court has done this piece by piece. So as Kerry said, when we say incorporation, we mean the idea that the Bill of Rights applies to the states. And when we look at this, the Supreme Court is going piece by piece. And what we mean by that is not just the amendments themselves, but the parts of the amendment. So Gideon versus Wainwright, for instance, is not about the whole Sixth Amendment, but about the right to counsel in the Sixth Amendment applying to the states, right? And here it was that Florida denied to Mr. Gideon, who was poor, or what we would call an indigent defendant, who could not afford a counsel and therefore had to try to represent himself. He became what we call a jailhouse lawyer. While in jail, he read case books. He tried to teach himself, and he's the one who actually applied for a writ of habeas corpus that reached the Supreme Court. He did it himself. So that case applied this to the, not only applied it to the states, but then also read it more broadly to say, not only is there a right to counsel that applies to the states, but states have to provide counsel for those who cannot afford it. So I think that's important, right? You get two components in that case that come along with incorporation. Roe versus Wade comes out of actually an earlier case that I feel like we could talk about more, which is Griswold versus Connecticut in 1965. The reason being is that it's a foundational case for what we call the right to privacy and the notion of that under the 14th Amendment applying to state laws. So that that had to do with contraception rights in Connecticut law, banning certain contraceptions between, I think, married couples and unmarried couples. There's actually two cases. So it's pulling out the right to privacy and applying that more broadly. So just think of it that way, because yes, we're talking specifically about abortion rights, and here a Texas law that banned them, except for in instances in which a woman's life was endangered. But this is about the right to privacy. I'll note, though, that while this is grouped under incorporation, the right to privacy itself is a broader right that's not under any specific part of the Bill of Rights. So it's that incorporation is not actually as clear as Gideon or McDonald's. So if you're confused, it's okay. It isn't as clear as it is in some of the other cases where we're directly pulling out text from the Bill of Rights and saying this applies to the states too. McDonald's the same way. McDonald is about the Second Amendment and the right to individuals to own a handgun in the home, which comes from District of Columbia versus Heller in 2008, which so Heller found that right for individuals to handguns in the home. McDonald, 2 years later, applied it to the states. What's really important to note is that by this point, the Supreme Court has come up with a test and a standard for what part of the Bill of Rights do get incorporated and what don't, and how do we know? And essentially it's, well, we look at the history to figure out what rights are fundamental and what are not.
Cool.
Without saying more, that's the gist of it. That's why we could talk about 10 other cases. I don't know what you want to say about equality.
So when we look, really this is just looking mostly at Brown versus Board of Ed and focusing on race-based segregation, but the 14th Amendment and how important the 14th Amendment is protecting rights of citizens. And we have about 4 minutes left, so I know it's a hard one to go through quickly, but let's hit the big idea in Brown.
Yeah, I mean, it is hard because we frequently spend a lot of time on it because we do the history beforehand to fully comprehend how we even get to Brown. But we do that in a lot of other classes. I think the key there, right, is that under the 14th Amendment's Equal Protection Clause, the court unanimously overrules Plessy versus Ferguson and says separate but equal is inherently unequal, right? And that's the real key, right, is that actually doesn't promote the equality demanded by the Equal Protection Clause, because it in fact creates classes of citizens. And one class over another class is inherently unequal and has a variety of pernicious effects that the 14th Amendment does not allow for. I think that's the best way of thinking about it.
Yeah.
We are talking about public school context, and that is very important, right? Mm-hmm. But I would say, hey, look at our other classes, read that history. There's so much there that you can explore. Citizens United, frankly, this could be put under the free speech emblem because that's generally what we're talking about. This is a First Amendment case that has to do with a campaign in 2008. A group basically made a video about Hillary Clinton, who was a candidate for president in that election, under 60 days before the election. And that violated the law, the McCain-Feingold Act. And this was the question of if a group, a nonprofit, including corporations or labor unions, can they have their right to speak diminished on political subjects, in something like that particular window. And this case is a pretty broad view of free speech rights, which is to say that you are a group of people as opposed to a single person, whether you're speaking as a nonprofit, a labor union, or a corporation. You do not have your free speech rights diminished just on that basis. And so therefore you can't restrain them in the ways that the government sought to do so. So again, think of that language we talked about from New York Times, for instance, of restraint and why the government can restrain things. It's the same theme of government has to give a good reason to do so. This isn't a good enough reason to do so because it would affect too much speech. And generally speaking, we try to uphold more speech.
So the next grouping, and we have two more groupings, this and then one more. So quality of representation. So we look at these two cases in Baker v. Carr, we're talking about one vote, one person, and then Shaw v. Reno is looking at gerrymandering, which is a really hard concept for everybody, not just our middle school and all of our intro students. So can you kind of like break down these cases? What are the big ideas? So because we have about 1 minute left to jump to the last one.
Yeah, I mean, Baker, I think the most important thing to come out of there is that the Supreme Court says the federal courts are open to taking these cases. Previously, they had treated questions of vote dilution, essentially, as we would call it, is political questions, to say like, well, that's what state governments decide. And we can go back to federalism in some respects with that and say the Supreme Court declined to get in the way before. And in Baker, they did. There's a lot to get into there. Basically, what happened is in Tennessee, for 60 years, they didn't change the districting. They didn't redistrict, even though their state constitution said they had to every 10 years. And the Supreme Court was just saying, we will take those cases now because there's an 14th Amendment argument there. There's an equal protection argument. The court should be open to hear that. It's cases right after there that we really get the enunciation of the one person, one vote principle, because the door is open, then the cases come in, and then that's where we really get that idea. And Reno, I think the easiest thing to say about that is it's racial gerrymandering too, which is to say these are what we call minority majority districts, which is to say if you draw state lines within a state to create a district where minorities have political power because they're majority within that district, is that also a violation of the Equal Protection Clause because it's on the basis of race? And that's a really hard question. And that's a question the courts are still grappling with even after Shaw versus Reno. So that is a hard question about this broader theme.
And something that our students should definitely pay attention to because it might be happening in their state. I know, Milo, it's happening in your state because I know what state you live in. And last but not least, so good for this one, you get to end with Marbury v. Madison. And hopefully I didn't butcher the name because I always say it goofy.
Yes. Marbury versus Madison, yeah.
Thank you.
Yeah, and I see in the comments too, and just for the students who were saying that, yeah, that's the whole thing is, are weird shapes acceptable? That's kind of the wrong question. The Reno question there too was, if you draw a really weird, arbitrary looking shape to promote this type of thing, is that okay? Should the Supreme Court accept that? It's a tough question. And Marbury kind of just takes us to the bigger one, right? As we took all these other pieces and now we're asking the real big question is, how do we have this role of the court in the first place? To be the final, is the Supreme Court, are they supposed to be the final reviewer of constitutional questions in our system? That's a pretty core question. That's judicial supremacy. But then even judicial review itself, right? The notion that the court's job is to review constitutional questions and disputes and to settle them, including ones between states and that come from states. And Marbury versus Madison is all about laying down that fundamental idea and principle by Chief Justice John Marshall that indeed the role of the Supreme Court is to interpret and that they must interpret, right? They must do this.
They must figure out what it says and what it means.
Yes,
it's like the easiest way that he lays out.
It's following from Alexander Hamilton's Federalist 78, which everyone can read if you have time. It's always a great essay to read. It's about getting the sense of what the role of the judiciary is we put it. What is that? And so Marshall is taking a dispute and he's using it as an opportunity to explain what he thinks the role and power of the Supreme Court is. I think that's the big takeaway. We love to get into the specific facts of the election of 1800 and
it's too confusing.
All the silly things that's going on. But really what John Marshall's doing is he's saying, okay, ignore the actual specific question. Yes, I'm saying this piece of this act is unconstitutional, but I'm telling you why I can say that's unconstitutional.
So would you call him a little opportunistic in this case?
Yes. I mean, I think a lot of John Marshall's, scholarship about Marshall, biographies, there's going to be another one. There's so many of these, is that Marshall was a Federalist. He had been in the Adams administration. He had a lot of experience. And John Marshall fully understood the stakes that were going on, so that Marshall would have thought this is a chance to finally say what and why the role is. It's not it doesn't have to be opportunistic so much as it is.
I don't mean that in a bad way.
No, it's like sometimes a case is a space to carve out good reasons, because he's laying down this thing the Supreme Court does so often now. But they didn't do that before then. The Supreme Court wasn't that powerful in the 1790s. John Jay famously left and declined to come back as Chief Justice because he thought he'd rather be governor or, an ambassador, because who wants to be Chief Justice? But John Marshall is laying down that idea of the Supreme Court can also use cases to explain principles and give reasons that can be influential going forward, right? We think of the Supreme Court doing that now, but I think that's largely only because John Marshall set the precedent of sometimes the court is going to almost use cases is like political theory and a chance to talk to the public and say, hey, here's what the court does and why it does it, and here's why we're doing it here.
And that's exactly why they put it into this lineup of important cases that the advanced placement college board team wanted our students to know. So utilizing this case to set precedent, set the tone of the courts, but also kind of help define what that Article 3 really means by the actions and by the authority. So Nicholas, thank you so much. This was a great review of these cases. Students, if you're taking the AP exam or if you're not, these are important cases to know. And the connecting dots between the cases are really, really fascinating to know too. So I'm going to pause the recording now, but we are going to hold on after this because we do have some questions in the chat for our students that came towards the end. So hold on one second, everybody.
Yes, and the answer to Derek's question is no. John Marshall was the 4th Chief Justice. So John Jay was